had to do with the scope and effect of various clauses under Article 60. That has to do with the succession architecture, so that in the absence of the president, the vice president shall act, and in the absence of the vice president, the speaker. Now, what if we have all three of them absent from the jurisdiction around the same time? Various schools of thoughts, have expressed different opinions. I have seen that you have a book titled Approaches to Interpretation, Purposivism, Living Constitutionalism, and Intentionalism in Ghana. Major setback in constitutional interpretation as a matter of public law and rights in Ghana, published by Nexus. I want to tap into your rich experience in terms of the application of the purposive application to this particular provision of the Constitution. Do you think there's a lacuna?
Thank you, Chair. In addition to what you have said, that article, I have 7 other books. Most of them have discussed these things. Yes, when we talk about the absence of the president, there is something in interpretation which we call capping legitimacy, meaning that whenever you are interpreting or wherever you are providing events, it should end somewhere. So here, if you look at the intention of the lawmaker or the purpose of the law, at any point in time, one of the three must be in Ghana. You cannot extend it to the Chief Justice because the law does not say so. If you go to Article 57, precedence, where the law wanted to say so, the law said that precedence, in the absence of the president, it is the vice president and speaker and Chief Justice. That one is about precedence in the absence of this. But when it comes to in the absence of president, vice president, speaker, in terms of governance, it is not the duty of Chief Justice. It was Professor Kruje who in the case of Asare as Attorney General, 2003, 2004, expressed a decision which was not ratio in the matter. It wasn't the ratio in the matter, in which he stated that to him, in the absence of the speaker, it should be the Chief Justice. It was a personal, it cannot be a ratio. Because if you read it, it is an obiter, and obiter does not bind any court. Because that was not the issue before the court. So my simple understanding is that it is to give legitimacy and to end the cap. So the cap has been fixed, the three. Because why do you go? So in that sense, you also go to say that in the absence of the Chief Justice, then in the absence of that person, in the absence of that person, then what is the essence of providing for leadership in your country? That is the essence. Thank you.
Thank you very much.
Thank you.
Any
there's
follow-up?
That's right. So by your interpretation, what if by necessity, and there is a Latin maxim that says that necessitatis non habet legem. By necessity, we don't have the president in the jurisdiction. Maybe the vice president has been taken ill, and then the speaker obviously had to be out of the jurisdiction. There can't be a vacuum. Somebody necessarily has to step in.
Well, I will allow.
It's just an academic exercise.
I will allow the supplementary question subject to the aspect that says the vice president is ill, because the Constitution used the expression absent from the jurisdiction. So, my Lord, you may proceed to answer the question.
Thank you, Mr. Speaker.
Thank you. You know, there have been 2 Supreme Court decisions on what do we mean by absence of the president, vice president, or the speaker. And it is the interpretation that has been given. And to me, that interpretation to me, contrary to purposive interpretation. Because we must look at the purpose for which the law was made. And why do we talk about purposive interpretation? Purposive interpretation means we look at the purpose, and the purpose is determined by time, circumstances, and development. The things that we had 20, 30 years ago, they are not the same as now. So I believe if in future that there should be a decision, the time and the circumstances may change the decision that the Supreme Court may render. It is possible. And we are saying that the Constitution is a living organism capable of growth. And the Constitution can grow at any time, and the meaning can change depending on time, circumstances, and development. Thank you.
I will then give the floor to
Last
Honorable
follow-up. Last follow-up.
Bafo.
Mr. Chairman, aren't you enjoying the
You
discourse?
have exhausted your
Chairman,
limit.
I mean,
You,
aren't
well,
you enjoying, law students
the
are
majority
listening.
leader wants a follow-up.
Yeah, but Justice Denis, if you look at the provisions of Article 60, they clearly anticipate, and I do agree with you, that if the president is not there, the vice president is not there, the speaker. If all of them are not there, the vice president and the president are not there for a given period, the assumption is that, let's say if they are not there and will not come back, if they will not come back, then there must be an election in 3 months, and a new president will have to take over. So clearly the Constitution is firm on the people who can occupy the position of president or acting president, and for what duration they can act as president. So what could have necessitated an obiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Asarabes Attorney General, which I personally, even though it is an obiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him, because he was discussing the position of the law between 1957 and 1960, where in the absence of the Governor General, all the bills were passed, were signed into law by the Chief Justice. That was the position then. So he used that one, because that regime, the order in council 1957 is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at it, he was influenced by that position. But within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England, and the Chief Justice will sign to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person, or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong, because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think you, from your previous answers, you seem to me as a judge who has some belief in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation
But leader,
of constitutional
do I
interpretation?
take it that you are now having your turn?
Yes, I'm having my turn.
Very well.
You endorse the purposive approach to constitutional interpretation.
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions. From a purposive approach to interpretation, in this era where absence from the country is not the same as inability to perform your functions, in view of developments in telecommunications and etc., where you can even sit abroad and then chair a cabinet meeting, where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here, but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason, when both president and vice president are not there, there is a fundamental breach of the Constitution?
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction. And if you look at the decisions rendered by the Supreme Court, the one against Honorable Adjei, the Supreme Court said that no, the person must be physically present in Ghana. That was the intention at the time the law was made, because we were scared of soldiers, that the least the soldiers will come. And therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take into account technology, development, and move to different level. Nothing may prevent it, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue. Thank you, Honorable.
And can you reconcile a situation where the president is attending the United Nations General Assembly on behalf of Ghana in his capacity as president? He's there in his capacity as president, sometimes even on a state visit in his capacity as president. And then in his absence, the vice president is sworn in as the acting president. At that time, do we have two presidents for Ghana? The vice president is acting as the president. Yes. So the point I'm making is, do we have one president acting outside Ghana and another president acting in Ghana?
Thank you, Honorable Chair. Honorable Chair, that is why from the beginning I said that there is an issue with that decision, but it is binding on everybody until it is varied or set aside. But as you know, Supreme Court decision can change at any time, provided it is policy, such as this one. It can change at any time. That is why we say that it is a living organism capable of growth. And in the case of Zenita Lawrence, Justice Atuguba openly stated that because of modern purposive approach or purposive approach, meanings can change at any time. And therefore, if you go for even interpretation and you think that the meaning has changed as a result of time, circumstances, and the purpose, you can still go back to the same court. So I am of the considered opinion that now that we have modernization, technology, and those things, that position, in future, if the opportunity avails itself, it should be changed. Thank you, Chair.
That will not amount to rewriting the Constitution, will it? Because the language of Article 60 is quite clear. The circumstances have changed. That renders its application funny, if I may put it that way. But the language hasn't changed, and the language is not open to different interpretations and fidelity to the language of the Constitution. Will you keep changing the language of the Constitution because circumstances have changed that make its application quite, uncomfortable?
Thank you, Chair. Yes, that is why now in most countries those use constitution. They are talking about either living constitutionalism or purposive interpretation. Whichever you look at it from, if it is a living organism, if at the beginning it was at the ground level and circumstances are changing, the constitution will grow. And that one, it will not materially affect the substance. It is the meaning that you are going to attach to it. And either you use purposive approach to interpretation or the living organism, which the Constitution is supposed to grow, which Ghana has embraced into 4 and Attorney General. It has been celebrated that the Constitution in Ghana will grow. Otherwise, if you talk about pedantism, then we are going to talk about literalism. The Constitution will never grow, and it will cease to be a constitution. It will be treated like any other document, such as Ordinary Act of Parliament or CI or LI. But the Constitution is different. That is why we say it is sui generis. It is unique, and because it is unique, its interpretation may change depending on the circumstances, but it will not affect the substance of the law. And what I would also like to say is that when we are talking about living constitutionalism or purposive interpretation, what we seek to do is that the Constitution must be able to address normal and or abnormal circumstances through proper interpretation. Thank you.
I'm being guarded by my chairman. He says that I've asked enough questions.
No, it's far from that.